it. We have that right. So we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one garage, not a blade of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one garage, not a blade of grass. We are a peaceful people. Struggle is always struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one garage, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Big mistake. Cause we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one garage, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one garage, not a blade of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one garage, not a blade of grass. We are a peaceful people. Struggle is always struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one garage, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time on it. Though we may criticize it, this is our own, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one grass, not a bit of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We are a peaceful people. Struggle is with struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one grass, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time on it. Though we may criticize it, this is our own, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one grass, not a bit of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We are a peaceful people. Struggle is always struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We are a peaceful people. Struggle is always struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one cries, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We are a peaceful people, struggle is we struggle, and we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. This land is all I know, we gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere, make no mistake. Cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We love the open country of the Rupununi and the Essequibo, take time on it. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass.
Honorable members, Mr. Speaker.
Honorable members, I declare this 83rd sitting of the National Assembly of the 12th Parliament of the Cooperative Republic of Guyana to be duly constituted and in session. The clerk will lead us in prayers.
Almighty God, we are here gathered together. We most humbly beseech Thee to guide us in all our consultations, so that we may together build a land where knowledge is free, where the mind is without fear, the head is held high, Their words come from the depth of truth. Grant us, O God, your aid and guidance, so that we may deal justly with the several causes that come before us, laying aside all private interests, prejudices, and personal preferences, so that the result of our counsels may be to the glory of thy blessed name, the maintenance of true religion, the preservation of justice, the safety, honor, and happiness of the President, and the peace and prosperity of Guyana. Grant us, O God, the vision so to lead that all the people of this fair land may enter into that state of brotherhood and unity, with the mind is led forward by thee, with ever widening thought and action.
Amen. Please be seated.
Messages from the President. Announcements by the Speaker.
Honorable members, first let me congratulate those members of political parties in Parliament who have been elected to their party's executives. Congratulations. I'm also honored to acknowledge the presence of former Member of Parliament, Mr. Dunstan Barrow, the chairman and members of the National Resource Fund, and also to Mr. Barrow. He is accompanied today to Parliament by his 17-year-old granddaughter, Destiny Ebony Barrow, who aspires to be a representative of the people. Thank you very much. Welcome all. Ms. Isaacs.
Presentation of petitions. Presentation of papers and reports, etc.
Honorable members, I present to the Assembly 1. The minutes of proceedings of the 14th meeting of the Committee of Selection, which was held on the 17th of May this year. Secondly, annual report of the Public Accountability and Oversight Committee for the year 2023. And third, the annual report of the Public Procurement Commission for the period July 8, 2022 to July 7, 2023. And this would be the first report of the Public Procurement Commission that has been tabled in the National Assembly. Honorable Prime Minister, Honorable Minister Teixeira.
Mr. Speaker, I wish to present and table on behalf of the Prime Minister the annual report of the Public Utilities Commission for the year 2023 for the circulation in the House.
Thank you, Minister. Honorable Minister of Public Works.
Thank you very much, Mr. Speaker. Mr. Speaker, I present to the Assembly the Civil Aviation Registration of Civil Aircraft Regulations 2024, number 13 of 2024.
Should be a second.
Honorable Senior Minister in the Office of the President with responsibility for finance and the public service.
Thank you very much, Mr. Speaker. I rise, sir, to present to this Honourable House today the following papers, reports, and other documents. Firstly, the annual reports of the National Insurance Scheme for the years 2021 and 2022. Secondly, the annual reports of the Dependents Pension Fund for the years 2022 and 2023. Thirdly, the annual report of the Natural Resource Fund for the year 2023. And in that regard, sir, allow me to join you in acknowledging the presence of and in welcoming the distinguished chairman of the Board of Directors of the Natural Resource Fund and other directors and the respective chairs of the Public Accountability and Oversight Committee and the Investment Committee, sir. And fourthly, Government Notice number 3 of 2024 regarding the notification of receipts of all petroleum revenues paid into the Natural Resource Fund during the period from 29th March 2024 to the 30th of June 2024. Thank you very much, sir.
Thank you very much, Minister. Honorable Minister of Education.
May it please Your Honor, I take great pleasure in laying before the House the motion to amend an order, and I ask that be considered later on.
Thank you very much, Minister. Honorable members, let me apologize to the Honorable Minister of Parliamentary Affairs and Governance. Inadvertently, the report of the Public Procurement Commission was placed under her name.
I don't think it's a problem, Mr. Speaker.
Honorable Minister of Education, laying it, you formally have to present the order and then we will move the motion later on.
May it please you, Mr. Speaker, I table order number 43 of 2024, the University of Guyana Amendment Order 2024.
Thank you, Minister. Mr. Isaacs?
Reports from committees. Oral questions without notice. Questions on notice. Statements by ministers, including policy statements. Personal explanations. Requests for leave to move the adjournment of the National Assembly on definite matters of urgent public importance. Motions relating to the business or sittings of the National Assembly and moved by a minister. Introduction of bills.
Honorable Attorney General and Minister of Legal Affairs.
Thank you very much, sir. Sir, I present to the Assembly the Matrimonial Causes Amendment Bill 2024, Bill number 10 of 2024, a bill intituled an act to amend the Matrimonial Causes Act, and I move that the bill be read the first time.
Thank you, Minister. Let the bill be read the first time.
Matrimonial Causes Amendment Bill 2024, Bill number 10 of 2024.
Honorable Minister of Human Services and Social Security.
Thank you, Mr. Speaker. Mr. Speaker, I rise to present to the Assembly Family Violence Bill 2024, Bill number 11 of 2024, a bill intituled an act to provide increased protection for victims of family violence, to make provision for the granting of family violence orders, and for matters connected thereto, and I move that the bill be read the first time.
Let the bill be read the first time.
Family Violence Bill 2024, Bill number 11 of 2024. Public business, government's business.
Honorable members, we will now proceed with the second reading of the Fugitive Offenders Amendment Bill 2024, Bill number 6 of 2024, published on the 9th of May 2024. Honorable Attorney General and Minister of Legal Affairs, the Honorable Mohabir Anil Nandalal, SC.
Thank you very much, Mr. Speaker. Mr. Speaker, as it can be discerned from the order paper, we continue to honor our commitment to transform the legal landscape of our country. And the bill that is before the House is one of 5, I think, that is on the order paper, and each one, sir, has that transformative element in it. Mr. Speaker, the Fugitive Offenders Amendment Bill is one that is timely and very, very necessary as we continue as a country and as a jurisdiction in a region to combat organized crimes and to combat transnational crimes. Every country is required at periodic intervals to update the relevant legislation. And some 15 years ago, we made certain amendments to our Fugitive Offenders Act, as those amendments were deemed necessary then. 15 years hence, Mr. Speaker, many things have changed and amendments have become necessary and requisite. Mr. Speaker, before I get into the actual amendments, because this is a very special and specialized area of the law, I want, for the purpose of members of the House, to explain what extradition is, because the Fugitive Offenders Act is the piece of legislation in Guyana that governs extradition. And I can do no better, Mr. Speaker, than to borrow the succinct but erudite dictum of the late Chancellor Cecil Kennard, Chancellor of the Judiciary, of course, of Casikrang of Honor and Order of Roraima in the case of Sobers against the Director of Prisons, reported at 1999-60 West Indian Report at page 304, where His Lordship adumbrated as follows, and I quote, Mr. Speaker, with your leave: extradition may be briefly described as the surrender by one government of an accused person upon the request of another government to its justice system. It is part of an interactive process that has developed principles, practices, understandings, and arrangements that are shared and in large measure institutionalized within the Committee of Nations and quite often embodied in bilateral treaties. Yet there is no duty to extradite, unquote. So, Mr. Speaker, the first fundamental point that I wish to emphasize is that while extradition may be a legal process, it is a government-to-government engagement. It is based on comity and, as will be explained in due course, predicated upon the doctrines of reciprocity and mutuality, with the requesting state yet maintaining the freedom not to extradite. As Chancellor Kennard note, there is no duty to extradite. For example, under the Principal Act, as it is in almost all similar legislation across the world, the process begins with an inquiry made to the minister assigned the responsibility for foreign affairs, confirming the existence of the appropriate extradition arrangements between Guyana and the requesting territory. I know my distinguished brother, the Honorable Hugh Todd, will be speaking later. So the process of extradition, sir, begins with an inquiry made to my distinguished friend to put into writing to the requesting state whether or not Guyana has extradition arrangements with that particular country. Once that question is answered in the affirmative, a request is made to the prescribed authority. And in our case, the Minister of Home Affairs, my distinguished colleague, is that prescribed authority, who upon receipt of a request for extradition determines whether or not he will issue what is called the authority to proceed. That is an instruction directed to the magistrate of the particular magisterial district whether to trigger the extradition hearing or what is called a preliminary hearing. Of course, the Minister of Home Affairs will first have to satisfy himself that the request is in compliance with our Fugitive Offenders Act and in a compliance with whatever bilateral treaty we may have. Of course, the Minister of Home Affairs will do so after receiving legal advice. Similarly, upon the conclusion of that inquiry by the magistrate, and if the magistrate determines that the legal requirements have been satisfied for the person to be extradited, the magistrate makes a committal order for extradition. The committal order is transmitted to the Minister of Home Affairs, who ultimately decides whether the extradition should proceed. Needless to say, the minister obviously is acting on behalf of the government. So I pause here to emphasize that though extradition is a legal process, you will note, sir, that it begins by one minister and it ends at another minister. It begins by an initiative from one government and it ends at the initiative of another government. Professor Brownlee, in his thesis, Principles of Public International Law, 1985, 4th edition, explains extradition process as follows. And I quote again, sir, with your leave. Apart from trial in absentia and unsatisfactory procedure, states have to depend on the cooperation of other states in order to obtain the surrender of suspected criminals or convicted criminals who are or have fled abroad. Where this cooperation rests on a procedure of request and consent regulated by certain general principles, the form of international judicial assistance is called extradition. Much of the material on extradition depends on the questions of internal and particularly of constitutional law and the effect of treaties on municipal law. However, some courts, in granting extradition in the absence of a treaty, have abstracted from existing treaties and municipal provisions certain general principles of international law. The two leading principles are that of double criminality, that the act charge must be criminal under the laws of both the state of refuge and the requesting state, and that of specialty, according to which the person surrendered shall be tried and punished exclusively for the offense for which extradition had been requested and granted. Unquote. And I wish, sir, to add a third, which is normally implied in the second. And it is that the person extradited cannot be sent by the requesting state to a third state to be tried for any offense without being surrendered back to the state from which that person was extradited. The Fugitive Offenders Act, Chapter 1004, establishes the legislative framework for extradition of fugitive offenders from and to Guyana and for other related matters. All of the principles to which I have referred above are contained in the Act. Both Chancellor Kennard and Professor Brownlee adhere to the importance of international treaties. In Guyana, the position is no different. Our Fugitive Offenders Act owes its foundation to a treaty between the United Kingdom and the United States executed in 1925. Of course, at that time, Guyana was then a colony of Great Britain, and upon our independence and our Republican status in 1970, we maintained our obligations under that treaty. In many rulings from our court, the validity of that treaty has been questioned and its validity has been pronounced upon and affirmed and reaffirmed repeatedly. A fugitive offender, Mr. Speaker, is defined under Section 2 of the Act, and I quote, "A person who is accused or alleged to be unlawfully at large after conviction of an extraditable offense committed within the jurisdiction of Guyana or any Commonwealth, country, or foreign territory, and is or is suspected to be in any country or territory other than the country or territory in which the offense was committed or the person was convicted." Simply put, if a person in the United States commits an extraditable offense in that state, in the United States, and or is convicted of an extraditable offense in the United States, but flees to Guyana and is in Guyana, the law enforcement agencies in America can initiate a process to extradite that person to the U.S., either to stand trial if he has not been convicted, and in the case of conviction, to serve the sentence imposed by the court in the United States. And as I said earlier, it is based upon reciprocity, so the same applies to a person who has committed an offense in Guyana or is convicted of an offense in Guyana and flees to the United States of America. The authorities in Guyana will trigger the extradition process with their counterparts in the Department of Justice and initiate a process that will bring that person back to Guyana either to stand trial or to serve the sentence imposed by the Guyanese courts. An extraditable offense, as you would observe, is very crucial in the equation, and that is also defined in the Act. The Principal Act defines an extraditable offense as an act or omission constituting the offense. It amounts to an offense punishable with death, imprisonment for life, or a term of not less than 2 years under the laws of Guyana as well as the laws of the requesting state. And that is what I mean by mutuality. An extraditable offense is one that is an offense both in the requesting state as well as the requested state. And it must be an offense that carries a minimum of 2 years imprisonment. Extradition serves the essential purpose of facilitating international cooperation in the administration of justice by allowing for the transfer of individuals, accused persons, or convicted or convicts of crime from one country to another for trial or punishment. As posited by Justice Kirby in an Australian case, and I quote again, "In a world of increased mobility, interactive technology, and new forms of criminality, extradition represents an essential response to the characteristics of contemporary crime." So, I don't think that I need to underline the importance more than I have done of extradition and ensuring that our extradition laws are intact. The amendments that I am bringing here have already been enacted in a few countries in the Caribbean. I know for a fact that it has been enacted in Jamaica and it has been enacted in Trinidad and Tobago. And Mr. Speaker, I will go through the provisions of the bill, but I have heard in certain quarters the view, or rather the apprehension expressed, that these amendments will affect, or rather will weaken, due process in Guyana as it relates to extradition. Sir, I want to reject such a notion out of hand. And when I take the Assembly through the bill, you will see that such a concern and that apprehension is an unfounded one. First of all, sir, I have outlined already how the process begins. It begins with a confirmation from the Ministry of Foreign Affairs that the extradition relationship exists to facilitate a successful extradition between the requesting state and Guyana. Once that is confirmed, then the extradition request is sent to the prescribed authority, the Minister of Home Affairs. The Minister of Home Affairs practically will seek legal advice. The extradition request obviously will have the name of the person, the offense for which the person either has been convicted or is charged, a summary of, well, the evidence that is in the file in the country, duly authenticated. Of course, it will have to be established first whether it is an extraditable offense. And once that is established and the request is examined against the provisions of our Act to ensure that the person will not be extradited to a third country, etc., and those safeguards have been established, the minister will then issue the request to the authority to proceed. That authority is issued to a magistrate who is handed all the documents that would have come from, that would have been transmitted to the Minister of Home Affairs. And that document is examined by the magistrate in what is called a preliminary inquiry. The magistrate inquires into the documents by embarking on a process that is similar to a preliminary inquiry. If I may read, sir, section 15 of the Fugitive Offenders Act. 15.2, I will skip 15.1. 15.2 reads, for the purpose of proceeding under this section, a court of committal, that is the magistrate, shall have the like jurisdiction and powers as nearly as may be, including power to remand or admit to bail, as a magistrate conducting a preliminary inquiry has. We will debate a bill later this afternoon on preliminary inquiry. So the magistrate, when reviewing the materials for the purpose of extradition, is not determining guilt of the accused or innocence, but is simply looking at the evidence to determine whether in Guyana, because it's an offense that is like an offense existing in Guyana, in accordance with Guyana law, whether a prima facie case would have been made out for the person to stand trial. Once the magistrate forms that view, then the magistrate commits. If the magistrate is of the view that the evidence before him or her is incapable of yielding a finding of the establishment of a prima facie case, the magistrate discharges. If the magistrate discharges, the prosecution has a right of challenge all the way to the Court of Appeal. It will now be to the CCJ. If the defendant feels aggrieved by the magistrate court's finding of a prima facie case, they have a right to challenge the magistrate's finding by way of habeas corpus and judicial review in the High Court. So both sides have a right of challenge. I'm going through all of this so that to address the anxieties that I have heard in relation to this bill. Nothing in this bill alters anything that I have said. Nothing in this bill alters that. All the safeguards, the same process exists. I will now go to the bill to show what the bill does or seeks to do and what is different from the bill and what the current law is. So, the bill seeks, Mr. Speaker, to allow to be admitted into evidence in Guyana the record of the evidence that was adduced in the United States. Now, in my view, that is a far more superior position than what existed before. Here you have a complete record of the proceedings. And they define record of proceedings as documents, statements, or other evidence, including photographs, fingerprints, or other description of the person which describes the identity and probable location of the person sought. 2, a statement of the facts of the case, including, if possible, the time and location of the offense. 3, a statement of provisions of the law describing the essential elements and the designation of the offense for which extradition is required. 4, a statement of the provisions of the law prescribing the punishment for the offense. And 5, any other relevant document. So you have a comprehensive record of the proceedings, including the evidence that would have been adduced in a court or compiled by a prosecutor in the requesting state, along with a synopsis of the relevant law and the penalties should the person be found guilty. When you examine that volume and magnitude of information and evidence against what the existing law says, and it's too long for me to go through, you see, sir, that you have now a wider expanse of information, documentation, dispositions, statements, and other evidence coming to the Guyanese court. There is a provision that may cause some disquiet, so let me read it expressly and put it to rest. It says this: a record of evidence of the case against the person, including evidence that would not otherwise be as admissible under the laws of Guyana, shall be admissible in evidence. This part, I believe, may have caused some concerns, and perhaps my friends will speak about it. But that is why I emphasized the nature of the hearing and the nature of the process that the magistrate embarks upon. The magistrate embarks upon a process that is akin to a preliminary inquiry. Mr. Ramjatan will agree with me, the honorable member, that in a preliminary inquiry, you do not deal with admissibility of evidence. Admissibility of evidence is a matter for the trial. So the fact that they say here that evidence that would not ordinarily have been admissible will now be admissible is simply of no moment, because the magistrate, when considering, even before this is put into force, now, if a magistrate is to consider an extradition request, the magistrate has no jurisdiction or legal power to exclude inadmissible evidence. Once the evidence is relevant, he will have to admit it. The question of admissibility is a question for the trial judge. The other important point that I want to make, which I'll make more, which it would be understood even better when we deal with a paper committal bill, is that it is a coincidence that we are passing these two bills together, because the record of evidence is almost identical to paper committal, which is the accumulation of statements that would constitute evidence, put them before a magistrate, and the magistrate commits on that document, on those documents, after hearing the lawyers from both sides. That is identically the process here. The record of evidence will constitute the statements that I'm referring to, and that will become the deposition that the magistrate will review for the purpose of committal, in the same way that we will have in Guyana when we pass the paper committal bill later. So, Mr. Speaker, there is nothing in this amendment that can possibly compromise due process as it currently exists. And I want to reinforce that point. Now, there is a series of safety mechanisms now that to ensure the authenticity and to authenticate what is the record of evidence that the magistrate is going to preside over and assess. And the bill says this: an affidavit from an officer, a record of evidence of the case against the person referred to in subsection 1D is admissible in evidence if it is accompanied by, and these are the safety mechanisms. 1, or A, an affidavit from an officer of the investigating authority or of the prosecutor, as the case may be, stating that the record of evidence of the case was prepared by or under the direction of that officer or that prosecutor, and that the evidence has been preserved for the use in the person's trial, semicolon. So there's a prosecutor or an officer duly authorized who is authenticating that this is the evidence, and that this evidence is being preserved for the person's trial, semicolon. And that is the first requirement, but it follows another one. It's not or, and. I continue. B, a certificate bearing an official seal or stamp of a person described in subsection 5, and I get to subsection 5 just now, stating that in the opinion of that person, the record of evidence of the case discloses the existence of evidence that is sufficient under the law of the Commonwealth, country, or treaty territory to justify a prosecution in that country or that territory. So there's an opinion now that is being expressed, authenticated, stamped, and sealed with the official seal, telling the magistrate in Guyana that in my professional opinion, having assessed the evidence, there is every likelihood that this evidence will yield a conviction in that country. And the person referred to there is, if you look at clause 5 of the bill, is no other than the Attorney General or principal law officer of the Commonwealth, country, or treaty territory. So it's the Attorney General of the United States or a principal law officer in that whichever country or treaty territory, or the deputy or delegate of the Attorney General or principal law officer of the country or treaty territory, or D, any other person who has the authority of the Commonwealth, country, or treaty territory to control the decision to prosecute. The person who controls the decision to prosecute in a Commonwealth country is the Director of Public Prosecutions. So you're getting an opinion from the Director of Public Prosecution or the Attorney General that the evidence there obviously is certified, certifiable, valid, and an opinion of likelihood of success. And then it continues, sir, clause 6. Nothing in this section limits the evidence that may be admitted at any hearing to determine whether a person is liable to be extradited. So even after all of this, a magistrate in Guyana says that that evidence is not sufficient. That magistrate has a power here to call for more evidence. Nothing in this section limits the evidence that may be admitted at any hearing to determine whether the person is liable to be extradited. So if the magistrate needs more evidence to determine whether the person is to be extradited, the magistrate has a power to call for more evidence. Then it continues. A certificate under subsection 4B, that's the certificate that I referred to, purported to have been signed by a person described in subsection 5, that is the Attorney General or the DPP, shall be admitted by a court without proof of the signature or official character of the persons appearing to have signed it. Well, obviously, the seal of the Attorney General or the seal of the Director of Public Prosecution would be accepted. And as I said, each of these provisions would be reciprocal. The same thing, the same facilities that we extend under this act is what will be extended to Guyana when we make extradition requests. Without limiting subsections 4, 6, and 7, and those are the subsections that I referred to, in any proceedings under this act where direct oral evidence of a fact or opinion would be admissible, a statement made in any deposition or witness statement, official certificate, or judicial document taken, given or made outside of Guyana and tending to establish that fact or opinion, if duly authenticated, would be admissible as evidence of that fact or opinion. A standard provision now in all evidence acts across the globe, especially since with the advent of technology and so on, computer-generated documents, official seals, or what you call it, electronic signatures are all now admissible. So all this is saying that if the man signs his name and he has his official stamp, that is, you don't need him to come. In the olden days, you needed the maker of every document to present himself physically in court to tender that document. We have moved away from that position 20 years now. Since 2001, we amended our Evidence Act to dispense with those outmoded process. Clause 9 deals with whether documents are in English. It allows for the document to be translated into a language that the judicial officer will understand, etc. So, Mr. Speaker, this bill will augment and it will bring great efficiency to our extradition proceedings. In the past, you had all sorts of technical objections that used to be raised. And those objections have now been over. The law by itself, outside of the area of extradition, have overtaken those technical objections. For example, the paper committal. 10 years, well, not 10 years ago, 2 years ago, that would have been, well, it was objected to, as we will explain, when we first introduced it in the Sexual Offences Act. It was challenged, not only in Guyana, it was challenged all over the Caribbean. It went to the Privy Council. Why? Because lawyers couldn't grapple with the idea that you can commit a man to stand trial for murder on paper without hearing a witness, without the man being given a right to cross-examine that witness. That was unfathomable. Today, it is the norm, and it has been forensically examined by the highest courts across the globe. In the Caribbean, the Privy Council; in Guyana, the Guyana Court of Appeal; and in Commonwealth territories across the British Commonwealth, where appellate courts have had to pronounce, because change carries with it suspicion, and lawyers are suspicious. Mr. Ramjatan might come here and see all sorts of things wrong with this amendment. I hope he doesn't. But I know the proclivities. I know the sensibilities. So, Mr. Speaker, this is a positive regime of amendments. It will modernize our extradition law, and it will enable Guyana, as well as other territories, to concentrate and collaborate their efforts more efficiently in tackling transnational crime and criminals. Mr. Speaker, without any hesitation whatsoever, I commend this bill to the House. Thank you.
Thank you very much, Attorney General and Minister of Legal Affairs. Before I call on the next speaker, Ms. Geeta Chandan, there's a switch. So before you start, Honorable Member, Mr. Ramjatan, just two things. Congratulations to Chris Jones on his 17th wedding anniversary today. And our condolences to Honorable Member Roysdale Ford, SC, on the passing of his brother, and he's excused today from Parliament. Honorable Member, Mr. Kemraj Ramjatan.
Thank you very much, Mr. Speaker. I want to say that the Attorney General suspects that I might not give my full support for the bill, given my proclivities. But I want to indicate that I will do a juxtaposition of both, support it, but also state the warnings because of my proclivity. I can recall that we had passed a sexual offense bill here, and unhappily, it had to come back for amendments because of the ingenuity of good lawyers and also very commendable clients who were, well, not clients, but accused or defendants who might see inside of the law, whether they be on bail or in prison, where they get lots of advice from other lawyers in that prison, certain lacuna and loopholes in the bill. But in trying as best as possible to bring a world into order, and so that there will not be the escape from criminality or the escape from the sentences passed onto those who would like then to have jumped the jurisdiction from where they were convicted, it is necessary that we strengthen further Fugitive Offenders Act or Extradition Act all across the world. Because as we see today, criminalities of a variety of nature, a variety of descriptions, and because of the digitized world we live in, lots of dangers can be suffered to victims because of the activities of certain people, and so that they must pay for it. Or when they have not been convicted and they get away to another country, they must be caught and brought to justice. Extradition and Fugitive Offenders Act are but an extension of that principle, which states that the long arm of the criminal law will catch you ultimately. And this is but the institutionalizing of a system that still has its imperfections, that indeed, as we go along, we will perfect it even more to the extent of whereby we will have to catch those people, whether they are from other countries doing the wickedness, or whether they are from Guyana and they got away and we want them back in Guyana. It is fundamental then that, yes, indeed, that we seek to enhance all those institutions and also the laws that govern those arrangements. And to that extent then, I must say that yes, to a large extent, this follows that pattern of further enhancing and fortifying that institution and regulation. But I'm not going to allow the Attorney General to get away from his call that indeed this amendment does nothing really. It is an amendment that seeks to do an alteration to what we already have. That is why he brought it. And so, what is that alteration? That alteration largely comes from what, as against what we have now. What we have now is that record of evidence of the case against the person, including evidence that would not otherwise be admissible under the laws of Ghana. So, in the extant regime of laws that we have in Guyana, it must be evidence that is admissible under our laws. Whereas this amendment seeks to give a record that can have what is called, in my opinion, and based on my interpretation of it, inadmissible evidence. Inadmissible evidence. So there is obviously a derogation from what used to be, that it must accord to the principles of admissibility, namely relevance, cogency, compelling nature of the evidence, and all of that. But what we are now stating here is that whenever we do a record of evidence, we can have that which as evidence would not otherwise be admissible under the laws of Guyana. So take, for example, the Americans want a certain person who may be a communist or a, let's call it a Muslim terrorist or an ISIS that they want from Guyana. they can say there a lot of inadmissible things that were prior had to be admissible in a court of law in Guyana. And then they can say, well, look, we feel this way and that he had done that, and there will be a lot of inadmissible evidence in the record of evidence now that can say, this is the record, and by the way, it will be buttered up with all this fancy certificate bearing the official and so on, but it is inherently inadmissible evidence, which now they use to say we want that fella, Sheikh Habula, or some other person. And then we can have that. So there is an alteration here to degrade the quality of the evidence, lower to the extent of it being, under our laws, it could be inadmissible. But once they say so, we got to extradite the person. And that is what is the alteration. Now, I pondered on this, and I said, you know, we ought to get rid of bad people in Guyana, come what may, you know, because there must be some other evidence that the person was a bad person. But in especially political spheres of activity, like the Assange and whatever else, I know there is, because I have done that before in relation to a Canadian citizen, whereby you bring habeas corpus to the High Court judge. It was then Chief Justice Bernard, and she then, the magistrate had committed the person, and then she said, no, she's not going to allow that to happen. And the person is right now in Guyana. The trouble here is that you have an alteration that seems to just be glossed over by the Attorney General. Oh, it's not going to happen. It's not going to. Well, let me tell you something. There are going to be cases whereby you're going to have, especially from the powerful countries, wanting that their sovereignty to be superior to ours. They're not going to say, if we now go and ask America or UK or another big country that, look, we would like that fella to come back to Guyana because he committed crime, they will want to find out if indeed that our country is going to allow inadmissible evidence. They're also going to ask about the mutuality and reciprocity principle. But we are now watering down our standards of evidence to accommodate, in my opinion, and this is where in rebuttal he could probably indicate that I'm wrong, but it will still be tested. This will certainly be tested in court, that indeed it is not but an alteration that is downward. It is, and it is going to affect political animals and also religious animals that are wanted. Look, I wish to make that point to clear the air, because generally the other provisions you can say that they are satisfactory to the extent of strengthening the imperfections that we had before. And I want to say, Mr. Attorney General, this concern that some people have concerning what constitutes the record of evidence is an extremely valid one. Notwithstanding that, we would like to support it in principle for the purposes of ensuring that in the larger perspective of a bigger world order, that yes, we all have the capacities in which to send back at the request of other states the criminals and culprits that might have committed crimes there, and also for us in Guyana, when we make the request, that we do have them coming to ensure that justice be done unto them. Thank you very much.
Thank you very much, Honorable Member, Mr. Ramjatan. Now for the Honorable Minister of Foreign Affairs and International Cooperation, the Honorable Hugh Todd.
Thank you very much, Mr. Speaker. First of all, let me thank my dear colleague, Minister of Legal Affairs and Attorney General, for taking time to explain in detail the modification of this bill and how it relates to our involvement in the international community in terms of fighting crime and criminal organizations. And I think that is important for us as a country to ensure that we are able to meet the standards that are required of us within a very globalized environment where there are threats not only to nation states but the entire global environment or community. So, Mr. Speaker, I rise to speak in support of the presentation of this presentation, this honorable House, of the Fugitive Offenders Amendment Act of 2024. The Fugitive Offenders Act of 1988, while a comprehensive piece of legislation, has had to be amended in keeping with actions to modernize legal instruments and the need for Guyana to respond to the changing global environment that requires us to strengthen our practice and our implementation of provisions that would ensure that procedures for extradition are seamless and in accordance with international law. The Ministry of Foreign Affairs and International Cooperation is the first contact for extradition requests. Any such request is then transmitted to the Ministry of Home Affairs for processing. States are confronted with new and sophisticated operations by those who seek to engage in nefarious activities. It is for this reason that both the national and international level, both at both the national and international levels, initiatives have constantly being reviewed. This amendment is part and parcel of a number of initiatives in which we are currently engaged in fighting and combating transnational organized crime and cross-border criminal activities. We cannot operate in isolation in fighting these threats and in helping to ensure that justice prevails. It is important to be engaged in international cooperation efforts to counter transnational organized crimes, such as human trafficking, smuggling and trafficking in illicit drugs and goods, money laundering, sex slavery, and terrorist activities. Guyana is a party to a number of international crime and corruption conventions, namely the United Nations Convention Against Transnational Organized Crime, acceded to in 2004, and the three protocols in support of that convention. A, protocol to prevent, suppress, and punish trafficking in persons, especially women and children, acceded to in 2004. B, protocol against smuggling of migrants by land, sea, and air, acceded to in 2008. And C, protocol against illicit manufacturing of and trafficking in firearms, acceded to in 2008. Mr. Speaker, we are also a state party to the 2008 United Nations Convention Against Corruption, the only legally binding universal anti-corruption instrument. We also have signed bilateral extradition treaties as well as bilateral engagements that would provide for mutual legal assistance in criminal matters. Mr. Speaker, apart from these treaties and agreements which govern our obligations to fight transnational crime, we are affiliated to a number of key organizations working to fight financial crimes and prevent money laundering. Among them, the United Nations Office on Drugs and Crime, and the Financial Action Task Force. Under the Financial Action Task Force, Guyana is a member of the Caribbean Financial Action Task Force, through which the states and territories of the Caribbean Basin have come together to implement common countermeasures against money laundering and terrorism. We are also a part of Interpol, the International Criminal Police Organization, which allows us to benefit from a wide range of technical and operational support. So therefore, Mr. Speaker, we have to be vigilant and to keep pace with the evolution of crimes and how to combat them and to counter masterminds and criminal enterprise. Because today's crimes have become increasingly international, Guyana cannot afford to be insular. We have to increase our interactions and programs with our bilateral partners, as well as to be part of the efforts of the international community. Guyana is part of the negotiations taking place at the United Nations to draft a modern, legally binding convention on cybercrime and cybersecurity. This is to combat a crime that has taken on a most dangerous, complex, and intrusive character. Cybercrime incidents have increased in both frequency and severity and have extended beyond boundaries, affecting all nation states. Guyana will remain engaged in this process because we believe it is important to ensure that there is adequate and secure protection for online operations for work, research, commercial activities, and social interactions. Mr. Speaker, I have sought to provide an overview from the international perspective of the initiatives being undertaken to fight transnational organized crime and corruption, and this has a direct link to the bill before this Honorable House today. The amendment to the Fugitive Offenders Bill is a manifestation of the role being played by Guyana as a responsible member of the international community. The bill seeks to amend Section 24 of the Fugitive Offenders Act, which provides for the types of documents that may be admissible as evidence in extradition proceedings or other applications under the Principal Act. According to the explanatory memorandum prepared by the Honorable Attorney General and Minister of Legal Affairs, the bill also, and I quote, seeks to expand the types of documents that shall be admissible in evidence by providing for the admissibility of a record of evidence of a case and the procedural requirements for the admissibility of such evidence. End of quote. This includes, 1, documents, statements, and other evidence which describes the identity and probable location of the person being sought. 2, a statement of the facts of the case, including, if possible, the time and location of the offense. 3, a statement of the provisions of describing of the essential elements and the designation of the offense for which the extradition is required. 4, a statement of the provisions of the law prescribing the punishment of the offense. And 5, any other relevant documents. In essence, Mr. Speaker, this strengthened amendment would put in place easier, more practical steps to support extradition requests and to facilitate more satisfactory legal processes through the court. I am therefore in full support of the Fugitive Offenders Amendment Act of 2004, and I therefore commend my colleague, the Honorable Attorney General and Minister of Legal Affairs, and his staff for the meticulous work done that is manifested in the document before us. Thank you, Mr. Speaker.
Thank you very much, Honorable Minister of Foreign Affairs. And now we have the Honorable Member, Ms. Geeta Chandan, Edmund.
Thank you, Mr. Speaker. I rise to make my contribution to Bill number 6, the Fugitive Offenders Amendment Bill of 2024, a bill entitled An Act to Amend the Fugitive Offenders Act of Chapter 1002. Sir, this bill seeks to achieve a simple but yet important task. It seeks to amend Section 24 of the Fugitive Offenders Act, which provides for the types of documents that may be admissible as evidence in extradition proceedings. It sets out in Clause 2 to amend Sections 1, 2, and 3, and it also amends Section 24 by inserting subsection 4, 5, 6, 7, 8, 9, and 10. The key issues being considered in this legislative actions are the admissibility of evidence, records of evidence, among others. The government is on record stating that there is a need for this tweak, and it is born out of the necessity to broaden the admissibility of evidence in extradition proceedings. From the outset, it is important to note that the Fugitive Offenders Act was originally passed in February 15th of 1988. At the heart of any fugitive offenders law, there are larger issues that goes beyond the ministry or the Minister of Legal Affairs, and it is important to note that the original passage of the Act in 1988, it articulated clear and a structured use of the Act rather than the Act being dealt with in any arbitrary approach to its implementation. Effective extradition procedures are an essential tool of international law enforcement, and this is something that we cannot argue with, both in relation to domestic crime and increasingly transnational crime. New international legal frameworks are emerging with the objective of enhancing international responses to organized crime, which includes terrorist crimes and drug trafficking, among others. And we must all be aware of these increasing levels of transnational organized crimes, which are inimical to our national security and the safety of our Guyanese people. However, at the same time as the reinforcement of international extradition obligations in instruments such as the United Nations Conventions Against Transnational Organized Crimes have been established, less desirable developments can be observed in the erosion in form and in practice of the principles of extradition laws, which are intended to safeguard individual rights. The recognition and application of some long-standing legal principles, such as political offense exception, have been diluted over time, while the efficacy of others, such as the principle of speciality, has been compromised in practice. With Guyana becoming a major player in the global community, the question of extradition takes center stage. Mr. Speaker, as a movement about the world becomes easier and crime takes on a larger international dimension, it is increasingly in the interest of all nations that suspected offenders who flee abroad should be brought to justice. However, my contention is that this cannot be used selectively, since it brings into question the political objectives rather than the infraction of the law. In recognition of freedom of speech and fundamental rights, this should not be used at the whims and fancies of any government to satisfy their narrow political gains. People here or abroad or in the diaspora, they have and they're entitled to freedom of speech, and I'll qualify that by saying once that is within the confines of our laws and freedoms of expression of speech, people are entitled to their views, even if those views are against what we agree with. So what I'm saying, sir, is that the establishment of safe havens for fugitives would not only result in danger for the state, but it will also tend to undermine the foundation of extradition. We all know that extradition has become recognized as a major element of international cooperation in combating crime, particularly, like I said before, transnational crimes such as drug trafficking and terrorism. And with the way things are progressing now, we know that this list is very exhaustive. And since these crimes continue to increase in our region, we rely on sustained international cooperation, which is critical to states like Guyana. So, sir, this amendment cannot only be taken lightly. Crime has significant social and economic costs that undermine our safety, our security, and our prosperity. And this is particularly true as Guyana finds herself with the name tag of being the fastest growing economy in the world. So this comes with transnational consequences and the need to have laws that are aligned for any eventualities. Our increasingly changing global environment is presenting new opportunities for criminal groups to expand their illicit enterprises beyond the traditional state borders. And this expansion and new techniques by these criminal groups increasingly add to the efforts to escape justice. This means, sir, that a high level of international cooperation is crucial to effectively combat crime. I am of the view that I view this amendment, sir, through the lens of the aforementioned. And it appears to me, sir, that the government has two objectives in mind: to modernize our extradition laws, and we have no problems with that, and to ensure that the Guyana can offer a broad range of assistance to our international partners. And we on this side of the House, we cannot argue with that. We fully support this. But it behoves members of Parliament to scrutinize every legislation that passes through the House. For this reason, Mr. Speaker, I've carefully examined the amendment. And I've noted the principles of extradition. And I reiterate the need for government to use this legislation not for political reasons, but to safeguard the state and the people of this country and our citizens. Lest we forget, the process for extraditing a person can be cumbersome, and it takes several months to finalize, even if a person has consented to their extradition. Although all stages of the extradition process will need to be completed, the safeguards built into the extradition regime will still apply. So there must be the interest of the state considered, and equally as well, the rights of the individual. The amendment at its core concerns the admissibility of evidence, and my colleagues in the Attorney General have spoken on that, so I will not go much into that. But for evidence to be admitted, we all know that in criminal trial, it has to be relevant, material, competent, etc. So this means that the evidence must help to prove or disprove some facts in the case. And we are reminded that it doesn't need to make the facts certain, but at least it must tend to increase or decrease the likelihood of some disputed fact. Evidence is competent if it complies with certain traditional statutory notions of reliability. So in extradition arrangement, our government must consider the extradition laws. So, Mr. Speaker, what I need from this government is that there's a guarantee from them that as a matter of principle here, that they will ensure that what we're asking for, that other states will reciprocate the same thing. As a key aspect of extradition arrangement is the concept that what we are doing at our end is being done at the other end of cooperating states. And I'll also like to state, sir, that we must accept that we, in an integrated world, and given Guyana's new status in the grand scheme of things, this type of legislation is very necessary. So kudos again to you, Mr. Attorney General. I think maybe this is the 5th or 6th time that I am commending you in succession. But, sir, like all things, when it comes to the People's Progressive Party, one wonders whether such legal mechanisms will be misused, as in the case with everything that the government touches for political purposes. And we fear, justifiable so, that these powers here will not be used in the manner it is supposed to be used. And we want to have that assurance that these powers here will not be misused. And this here is a very fair concern that we're asking for, sir. We want to be assured that subjects and friends of the government. You know what I want to say, Mr. Attorney General. You know that. You know what I want to say. So what I want to say is what I want you to give us the assurance, Mr. Attorney General. I've commended you successfully. I've commended you successfully. I think you're one of the most progressive Attorney Generals we have. But I want you to give us the assurance that the powers under this legislation here will not be misused. I want the assurance that you're not going to misuse this for political purposes. And that's all I'm asking from you, and I don't think that is an unreasonable request. With that being said, I thank you.
Thank you very much, Honorable Member, Ms. Geeta Chandan Edmond. And now for the Honorable Minister of Home Affairs, Robeson Brinley Horatio Ben.
Does that make sense to you?
Mr. Speaker, honorable members, I rise in support of the amendments to the Fugitive Offenders Amendment Bill of 2024. I know that at least three lawyers have spoken before me. The Honorable Attorney General has spoken in detail on the requirements, on the amendments, the necessity for those amendments, and why we continue through the PPPC government to make the necessary steps, sometimes delayed over the years, and given the fact there was a certain interregnum, that we are continuing in our efforts to upgrade, to make modern, to make our laws in consonance with our international obligations, and also too, in making more efficacious the use of our laws in respect of our own Guyanese people. Mr. Speaker, the responses that we have to make in respect of transnational organized crime relate to also to upgrading our laws. Guyana is a victim of transnational organized crime. Many of the crimes you see and what the police call disorderly crime and our usual, perhaps, bad behavior relate, as was suggested to before, issues of drug trafficking. We are victims of that. The fallout in relation to money laundering, gun crimes, smuggling of persons, trafficking in persons, and all of those issues, these new forms of crime require modern approaches. adequate modern legal approaches. They require our upgrading our relationships in relation to the treaty obligations we have with other countries in respect of our laws. And so the overall question of the Fugitive Offenders Amendment Bill, the overall question of our tackling the issues relating to transnational organized crime are inherent in this approach in terms of the Fugitive Offenders Amendment Bill. We have had perhaps, and of course, when issues in relation to extradition, as was mentioned by the Attorney General, related to when we were a colony. And then we had the 1988 law, and then since then, we have been looking where we can beyond issues of finding fugitive offenders where they perhaps may have committed a crime in Guyana and where we have had to resort after they would have served a sentence in Guyana to deport them to their jurisdiction where they may have come from and where their issue would be dealt with by the courts of their country of origin. As was said, we have our relationship with Interpol. In the Ministry of Home Affairs, we have the treaty office and persons there who look at the matters which come to our attention through the Ministry of Foreign Affairs. And we have been fairly busy with respect to these issues over the period. I believe reading the various sections, clauses of the bill, that it brings in greater transparency, that it relates to giving greater certainty in respect of the approaches and the record of evidence which will be put towards proceeding with cases of extradition of fugitive offenders. I am a bit worried about the former Minister of Public Security raising questions of inadmissibility of evidence in relation to what is presented to in this bill. In fact, I'm surprised that he would be speaking, but a lawyer can talk on all six sides of an issue. They've just got to be paid in many instances. They won't do it for free. The clauses in the bill 2.4 speak to a record of evidence of the case against a person referred to in subsection 1D is admissible in evidence if it is accompanied by an affidavit from an officer of the investigating authority or of the prosecutor, as the case may be, stating the record of evidence as the case was prepared by or on the direction of that officer or that prosecutor, and that the evidence has been preserved for use in the person's trial. Follows at B with the question of a certificate. It follows with the person referred to, of course, as the Attorney General, as the principal law officer of the Commonwealth country or treaty territory. And at 6, it says, nothing in this section limits the evidence that may be admitted at any hearing to determine whether a person is liable to be extradited. And it speaks to those issues directly, these amendments. And so the concerns, I don't want to say that they may be of a personal nature, but the concerns that Honorable Member Kemba Ramjatan is bringing up here with respect to the admissibility of evidence in these cases, I believe are adequately accounted for in the amendments in this bill. It speaks to questions of direct oral evidence, the question of a fact or opinion would be admissible, or a statement made in any deposition or witnessation, official certificate or judicial document taken or given or made outside of the intended to establish that fact or opinion, if duly authenticated, is admissible as evidence of the fact or opinion. And then it speaks of translation, and not artificial intelligence translation, but translation by which is certified by a judicial prosecutor or penal authority or other officer administered government department or of a common country or treaty territory, and purports to be an accurate translation of the original document. And it goes to talk about the document, the judicial document, the record of evidence in the case, and which include documents, statements, or other evidence, including photographs, fingerprints, or other description of the person which describe the identity and probable location of the person, so on. Statement of facts of the case, including the possible time and location of the offense, and a statement of the provision of the laws which describe the essential elements and the designation of the offense for which extradition is requested. This is quite detailed, necessary, and given the fact, as we said, as was said previously, the challenges we have in relation to transnational organized crime, the issues of digitization and digitalization of information, the questions of how soon information could be got and brought over into evidence for review here in Guyana or in the country requesting the extradition. So I want to clearly support the facts as stated out here, the result we have in the amendments proposed in respect of the admissibility of the evidence. Of course, there's been a history, and more recently we've had, and it was mentioned, the now celebrated case of Julian Assange. Spent a lot of time, I think, in the Ecuadorian embassy, and then did a deal back home now. And we've had cases, and we don't want to be in that position, where we don't have enough safeguard in our laws which would allow for situations which have occurred in other jurisdictions or between states where people might be rendered, and we might remember the issues of rendering of persons from particular states when we had the terrorist acts in the Middle East. I hear that there's a question from the honorable member who spoke before, Ms. Gisa Chandan Edmond, about selective, whimsical, or other means for political purposes of using these amendments to the law. I can only suggest for both members, if they have particular amendments to propose here on the floor now, in respect of these issues, to propose the amendments, that there will be sufficient time, given the critique. Well, I don't know what they are. And I heard Ms. Gita Chandan Edmond appealing to the Attorney General not to use things for political purposes. And to me, basically, first of all, it's a slur to suggest that the PPPC will do that. Secondly, there are the courts, and the strengthening of the resorts in this document itself along with the amendments proposed to the principal law, the act, suggests that it could not be so and it could be responded to. So it is unfortunate that the type and quality and level of critique that has been made is disappointing. Bring amendments. Let's bring amendments. Bring amendments. Let's do the work. The Attorney General and his staff and the Foreign Affairs and ourselves have all somehow weighed in on this issue. And if there is any serious concerns, if they wanted us to have a debate, a discussion on the issue, bring the amendments. Mr. Speaker, I believe that on the overall question of provenance, in respect of the types of documents which are proposed to be brought into view and in relation to the review of the question, in question of the completeness of the records that are required now as a result of the proposed amendments of the Principal Act, in relation to improving transparency in relation to the persons who would be reviewed or whose cases may fall under review in respect of this act. I think it could not have been a better submission by the Attorney General for us to look at amendments to the Fugitive Offenders Bill, the amendment to the Principal Act. We, of course, have had a number of actions undertaken. I would say in 2021, we have 5 or number of requests sent from our side for mutual legal assistance. We have had 12 done over the last 4 years in terms of requests sent. We have had a number of persons who were extradited to the United States of America. There is one which is still pending appeal. At the moment, we have 2 requests for mutual legal assistance which are under review. And I don't know as yet that any person here should be worried about the question. I'm sorry that Ms. Gita Chandler Edmonds said that persons are entitled to their opinion, whether we agree with it or not. It depends on what is expressed and said. When persons, I'm glad that I'm not a lawyer. I'm so glad that I'm not a lawyer. I don't think my mean will allow me to be a lawyer. But anyway, the point I want to make is that I won't talk about our own example because then we'll be quarreling again. But I want to talk about the insurrection which was attempted by a former President of the United States and his people who stormed the Capitol. And that many of those persons who did that and said things are going into the prison now. And so, I want to remind ourselves of that if you think you can say write libelous things or say slanderous things or propose or want to traduce the state, you want to propose insurrection. We talked about somebody or some persons who are perhaps in the safe areas of the United States at the moment which said, Georgetown must burn down if the PPP income. Georgetown must burn down if the PPP seem. I'm saying for some of those statements which we have on record, we are considering mutual legal assistance in relation to those matters. We have to. We have to. And I'm glad that the Honorable Comrade Ramjatan here on this floor and the Speaker somehow allowed us to take an independent course of action when he agreed with me that if persons said those things and are suggesting and promoting those things, he would not support it. And I think it should go for the whole of the AFC.
He can't speak for them.
I don't know.
He's not in a
Well, I don't know where he is right now. I was surprised that he is here today. But in any event,
there's a heist over
there is a lot of toiling and trouble on the other side. I still think that there's still a conquer on the way, and I want to encourage our opponents on the other side, particularly in spite of them evincing some support for these measures, that when they say certain things, it should be thoroughly considered and said, and if they really want to debate, they must bring amendments. And with that, I support these amendments and the revisions, the amendments for this bill brought to the House by the Honorable Anil Nandlal, or Attorney General and Minister of Legal Affairs, ably supported by the speakers on this side of the House. Thank you very much.
Thank you very much, Honorable Minister Ben. And now for the Honorable Attorney General and Minister of Legal Affairs.
Thank you, Mr. Speaker. And I want to begin, sir, by thanking my two colleague ministers for their sterling contributions on this bill. And I am, of course, magnanimous, so I will thank the Honorable Member Comrade Ramjatan and the Honorable Member Geeta Chandan for their support. However, they have diluted that support by making some very uninformed statements. And I'll begin with the Honorable Member Geeta Chandan first. Several times during the course of her presentation, she felt the need to solicit and enlist from me some type of assurance that this bill will not be used for a political purpose. And that by itself demonstrates, Mr. Speaker, unfortunately, that the Honorable Member doesn't understand how extradition works. So I will rehash. So, Madam Geeta Chandan, first of all, Honorable Member, our political party, and Comrade Ramjatan will support me. You are young, under the PNC, every other year, every other term, they use a charge. Rigging elections, of course, that's a given. We're not debating that. They used to charge one set of people for treason after another without any evidence whatsoever. The Maikoni 4, the Mahaika River 4. I'm not even reaching around. I'm talking about treason charge. I know it was a fabricated murder charge. Then you have the Leonora 4, You have Sanasi and the other policeman. Ramjatan used to go at all the police stations looking for treason accused. And without any evidence whatsoever, nothing. In Mahaika Creek, you know, you've come from Borbies. You know, they used to Christmas time, they used to put a thing named carbon, you know, for tin, shake it and light it, and used to go, pow! Well, a man had that in Mahaika Creek. He named Hardat. And they charged him with treason. Just because he was in possession of that. So that is the culture that you are part of, Madam, Honorable Member. The other day I was doing some research and I found that I have it in my phone and I will enlarge it and bring it to you. The PNC flag on the face of the Court of Appeal building next to the coat of arms. That is the culture that you are part of. Walter Rodney, an outstanding Guyanese scholar and leader of the WPA, was blown to pieces because he was opposed to the government of the day of which you are a part, the party. And I can continue. No, you see, when you put these things on the record, it is necessary for me to repudiate them. So you must never, ever let us deal with Crummy Wing. You had 5 years in government to investigate Crummy Wing. You never did it. You never did it. You held commission of inquiries for a dog that barked at President Granger. Why you didn't hold a commission of inquiry into Crummy Wing? You all like to blame people. The police evidence show that at the time when Crummy Wing, before he left his home, he received a phone call that triangulate to the Congress place, inviting him to go to Diamond to go and protest. Aksi Al-Basad, the Commissioner of Police. You want to talk about Crummy Wing? Why you didn't hold investigation into Crummy Wing? You must never be allowed to say these things to be left on the public record, creating some impression that though we on this side are guilty of it. Look, if we were disposed, if we were ever disposed the way that you are, the PNC, half of you would have been in jail already. Half of you would have been in jail already.
Okay, AJ, please.
So
you're speaking to me.
Yes,
I don't know
sir.
which half of me would be in jail.
Half of them would have been in jail.
No, again, you're imputing there. You're imputing.
Let me get back to the bill, sir. Let me say to the Honorable Member Geeta Chandan that if anyone violates the law of this country, our government will ensure that the law enforcement agencies investigate the allegation, and if charges are to be leveled, then charges will be instituted. And that has been our position for all the years that we have been in government. All the years. So, Mr. Speaker, let us deal with what the Honorable Member says. The Honorable Member somehow thinks that this bill will be used to prosecute somebody living somewhere who are offering views that we don't like. First of all, those people do that every day, every night, and they are allowed to do it all the time. Some of them have been charged, and the legal process will deal with them. But let's get back to the bill. The Honorable Geeta Chandan, former magistrate and attorney at law, please understand that when, let us assume, a person makes some statement that is considered to be an extraditable offense in the United States of America, then the request has to be made to the Foreign Affairs Minister, the Foreign Secretary of the United States of America, to verify whether we have an extraditable relationship. Then the request goes to the Department of Justice, where the prescribed authority lies. And then we in Guyana will have to send up all the evidence that we have, and then a court in America will have to preside over an inquiry to determine whether there is a case made out for that person to be extradited to Guyana. Do you understand what you are alleging? You are alleging that we can able to compromise the judiciary of the United States of America? And you are a former magistrate? Oh, Lord. That is why I said, the Honorable Member Quarry, I'm being unfair to her. The Honorable Member stood there and articulated her position. And all I am saying, that in that articulation, she made some uneducated statements. Highly uneducated. And I'm trying to educate the Honorable Member.
It's an effort in futility, my friend.
So it's not ropes and bends sending a love note to somebody in America and somehow, through some arrangement, somebody is going to be plucked out of their home and brought on a plane to Guyana. That is not how the world operates. That is how the PNC operates.
Correct. Tell them.
That is how you operate. You take 5 days to come 1,300 votes. That is how you operate.
That's right.
And then when the results come, half of you get thrown out. I'll get back to the bill, sir. So, Mr. Speaker, I want to assure the honorable members that the rule, once the People's Progressive Party civic is in government, the rule of law shall always prevail. What, an honorable member, why you withdraw? Why did you withdraw? Because the voters list was stolen. The voters list was stolen 1 month before. I would have withdrawn too. Look, you don't even know where you are. Are you in APNU or you're in the PNC? Relax yourself. So, Mr. Speaker, let me get back to the bill. So, the honorable member, I want to assure her that this bill is that is why it's a government-to-government arrangement. And unless the United States government or governments around the world conspire with the government of Guyana to extradite people, that is only how it is possible. That is only how it is possible. And I don't think governments around the world operate like that, Mr. Speaker. And the Guyana government certainly does not. And Honorable Member Gita Chandan, there is a list of offenses that a person cannot be extradited for, and they are listed here. Offenses of a political type, political nature, etc. That is why I said your presentation was highly superficial. You didn't read the substantive bill. You didn't read it. Had you read it, the honorable member, then you would have seen section 8. A person shall not be extradited under this act, and it continues. If the offense for which the person is accused or has been convicted is an offense of a political character. This is in Guyana's provision, and it is in the provision in the United States. B, the request of purporting to be an extraditable offense is on the account of a person's race, tribe, sex, religion, nationality, or political opinions. Second, and then another, madam, this make-believe world that you and the PNC live in, it don't exist. It only exists at Congress Place, where you can take 5 days to count 1,300 votes. It's a make-believe place. 29 million votes counted in England in 24 hours. 5 days, 1,300 can be counted. 29 million votes counted in the United Kingdom in 24 hours. And the explanation that came forward, you had CARICOM day, you only count night time, the counters were working. Mr. Speaker, I asked my driver to count 1 to 113 times, and he did it in less than 1 hour. 1 to 113 times, he did it in 1 hour. I drove from Georgetown to Mahaica and I count 1,300. And it took 5 days. And they have a GCOM commissioner counting. A GCOM commissioner too. A man who always speaks about the voters list. All day he speaks about the voters list. And he got a voters list of 1,300 and it took 5 days. But let's get back to the bill, Mr. Speaker. The honorable member, Kemra Ramjatan, has raised a point, and I did flag the point as an important one. And I thought that I was proficient in my attempt to offer an explanation. Unfortunately, my learned friend was not persuaded, so let me try again. So, Honorable Member Kemraj Ramjatan, let us start from the proposition, which I don't think you can dispute, that when the magistrate is considering an extradition matter, the magistrate is doing a committal hearing. You accept that as a general proposition. That magistrate is not conducting a trial, is conducting what is called a sufficiency evidence inquisition, for want of a better word. And you would agree with me that once he is conducting that process, he is not empowered to deal with the question of admissibility of evidence. You accept that? You don't. So let's go to the authorities which I have. So let's start with Blackstone. You know Blackstone is one of the most preeminent English authority in the world over 500 years, right? I respect that you want to hold your own view, but you must be minded of views such as Blackstone. So let's hear what Blackstone says. Blackstone is not a brand of liquor, no. It's a law book. It's a law book. Blackstone, sir, Mr. Ramjitan, 1996, Blackstone Criminal Practice, one of the foremost on criminal law and procedure in England, at page 1908, cites with approval the dictum of Lord Justice May in Oxford City Justice's ex parte Berry, at page 51, as an accurate declaration of the law. His Lordship stated thus, and I quote, "The question of voluntariness or otherwise of an alleged confession statement by an accused has hitherto seldom, if ever, have been investigated in committal proceedings." The admissibility of a confession statement don't be questioned at a committal proceedings. Why? Because the magistrate doesn't deal with admissibility. That's a question for the trial. Safe perhaps to have some matter, let's move on. That is a matter ultimately for the trial of the indictment. That's the English position. Let's come to the Caribbean. You know Dana Sita Hall, senior counsel of late, proficient writer, lecturer at the Wooding Law School. In the Commonwealth Caribbean, The preeminent authority in this area of the law is the Commonwealth Caribbean Criminal Practice and Procedure, second edition by Dana Sitahal, Senior Counsel. At page 171 of the text, the learned author deals with the issue of admissibility of evidence at a preliminary inquiry. The very issue, admissibility of evidence at a preliminary inquiry. After reciting the English practice to which I have alluded above, the learned author adumbrates the position in the Caribbean to be similar and as follows. I quoting from the book. This is an article that I wrote several years ago. Quote, in the Commonwealth Caribbean, examining magistrates act in accordance with this practice, the English practice, on the basis that disputed admissibility questions are for the trial court. At committal proceedings, therefore, confession of the defendant will be tendered into evidence, since its actual admissibility on the basis of voluntariness can only be determined in a voir dire hearing at a trial. Until then, it constitutes legal evidence. The point I quote those authorities to say to you, honorable member, that once you accept that the magistrate is conducting a preliminary inquiry and you don't have any basis not to accept that, because that is what the Act says. That is why I quoted section 15. And let me quote it again for the record. For the purpose of proceedings, I'm quoting from the Act, the substantive Act. For the purpose of proceedings under this section, a court of committal shall have the like jurisdiction and powers as nearly as may be, including power to remand or admit to bail as a magistrate conducting a preliminary inquiry. Shall have the same power that a magistrate has when conducting preliminary inquiry. A magistrate conducting preliminary inquiry does not deal with admissibility of evidence. That is a matter for the trial. But let us for one moment digress a little. You know that the rules of exclusion in America, well, there's a serious assumption of noise. Permit me to inform you that the rules of exclusion in the US are far more stringent than in England and in the English Commonwealth. For example, you have illegally obtained evidence inadmissible in the United States. Isn't that so? In England, however, and in Guyana, you can have illegally obtained evidence still admissible. You know that, right? And you know the poison tree argument in America. So they would hardly find a pragmatic and practical, factual situation where something would be admissible in the United States and not admissible in Guyana. Right? You understand? Then the other point I want to make to you is this provision 6, which I emphasized, I thought, but perhaps I didn't drive home the importance in the manner that I should. 6 says, nothing contained in this section, that is a section that as I just outlined, all the section that deals with the record of evidence and the inadmissible evidence now admissible. 6 says, nothing in those sections limits the evidence that may be admitted at any hearing to determine whether a person is liable to be extradited or not. You know what this section allows? Let us say you have a magistrate who may feel that, look, I am uncomfortable with this evidence that you have here, in this record of evidence. I am uncomfortable because, in my view, you have there inadmissible evidence. You have inadmissible evidence. When we deal with the paper committal just now, I will show you how inadmissible evidence will be admitted. And the courts have pronounced upon it already in the sexual offenses case. the paper committal, but I'll deal with it. So, Honorable Member, Mr. Mahipur, please don't distract the Honorable Member. I'm speaking to him. Yes, Honorable Member. So, if a magistrate, for whatever reason, forms the view that he is dissatisfied with the quality, the nature, and purport of the evidence on that record, there is Section 6 that invests in that magistrate a residual and residuary power to call for more evidence. So it is within the bosom of the judiciary to satisfy itself. It's a magistrate at the end of the day that must satisfy him or herself, either through what you are calling inadmissible evidence or calling for more evidence before that committal order can be made. Nobody else making the committal order. Nobody. Not Robeson-Ben, the Honorable Minister, not the Attorney General. At the end of the day, if a committal for extradition is to be made, it is a judicial officer sitting as a magistrate who will make that ultimate determination. So who else do you want us to reside the power with? How can you be worried about political interference? You always speak about the inability to get Lowenfield and Mingo on trial. That's another story. So the magistrates of this country will determine whether a case is made or not made out for the purpose of extradition. And as I have outlined to you, both the prosecutor or the requesting state and the defendant, the accused person, have rights of appeal upwards, all the way to the Caribbean Court of Justice. So, my friend, you have many more channels to go upwards to challenge the type and quality of evidence. So, Honorable Member Geeta Chand, and this fairy tale that you have in your head, that somehow this bill can be used to extradite people for political reasons, is quite uninformed. And I ask you to disabuse your mind from that type of notion. And Honorable Member Kemraj Ramjatan, I hope that I have put your objections and fears to rest by outlining to you the powers and the powers of the magistrate and the juridical and jurisprudential nature of the inquiry that the magistrate is going to be engaged in when this bill comes into force. So, Your Honor, Mr. Speaker, with those few remarks, I commend the bill to be read a third time. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Attorney General. Honorable members, I now put a question that the Fugitive Offenders Amendment Bill 2024, Bill number 6 of 2024, be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Fugitive Offenders Amendment Bill 2024, Bill number 6 of 2024.
The House will now resolve itself into committee to consider the clauses of the bill. Honorable members, the Fugitive Offenders Amendment Bill 2024, Bill number 6 of 2024, has two clauses. And I propose the question that these two clauses now stand part of the bill. Honorable members, I now put the question that clauses 1 and 2 of the bill, clauses 1 and 2, stand part of the bill. Those in favor say aye. Those against say no. Ayes have it. The two clauses now stand part of the bill. Honorable members, I now put a question that the bill be reported to the Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the Assembly resume. Honorable Attorney General and Minister of Legal Affairs.
Mr. Speaker, I am pleased to report that the Fugitive Offenders Amendment Bill 2024, Bill number 6 of 2024, was considered in committee, clause by clause, and passed without amendment. Thank you very much, sir.
And you know.
And I'm asking, sir, that it be read a third time.
And passed as printed.
And passed as printed, sir.
Honorable members, I now put a question that the Fugitive Offenders Amendment Bill 2024, Bill number 6 of 2024, be read a third time and pass as printed. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Fugitive Offenders Amendment Bill 2024, Bill number 6 of 2024.
Thank you, honorable members. I think this is a good time to take the suspension, and we endeavor to be back within 1 hour.
We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know, we gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere, make no mistake. Cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake.